this webinar on the Homes Fitness for Human Habitation Act. I am Alice Richardson, this is Tom Tyson, and we are specialist housing barristers at Trinity Chambers. As I'm sure you're all aware, the Act came into force on the 20th of March 2019 and has applied since that date to new tenancies created after that time. There was a 1-year grace period for existing tenancies, and so from the 20th of March 2020 this year, the Act has applied to all tenancies and is therefore somewhat of a hot topic. This webinar will address what the problem was before the legislation came into force, what the legislation does, potential remedies where it's been breached, and then some practical tips. We are also going to answer some frequently asked questions on what the current public health emergency means for housing conditions and disrepair cases. The webinar is going to take the form of a Q&A, and I have the pleasure of asking Tom the questions that I'm sure you're all very excited to know the answers to. Before we start, you should have received an email with a copy of the Act and a copy of the new protocol, so it might help to have those out in front of you as we go along. Let's get started. So Tom, what was the problem?
Well, the problem always was that so far as repairs were concerned, and repairs that landlords were responsible for in short leases of residential dwelling houses, Section 11 of the Landlord and Tenant Act simply implied a covenant into every short lease that the landlord would repair and maintain the structure and exterior of the dwelling house. So while this extends to the drains, gutters, pipes, and facilities for space heating and water heating, it didn't cover the sometimes appalling living conditions caused by a defect in the design or the original construction of the house. And in those cases, nothing had fallen out of repair, but the premises were simply unfit for habitation. And to the surprise of many lay observers, there was no obligation for the landlord to place the premises in a state that was fit for human habitation.
There was some protection for tenants already, though, in terms of EPA prosecutions and the 2004 Act, but presumably those still didn't fill the gap that we're now talking about.
Well, no, I think they fell through the cracks, essentially, because a prosecution under the Environmental Protection Act of 1990 was and still remains a possibility, but there the tenant has to go to the magistrate's court and show that the premises are prejudicial to health or a nuisance. Mm-hmm. The procedure in the magistrate's court is perhaps somewhat more cumbersome than county court proceedings. And whilst the magistrates have the power to make a compensation order, there is a statutory maximum. And I think to many practitioners, it just seems to be quicker, more effective, and more sensible to give every tenant a direct contractual right that they can enforce by way of county court proceedings.
And what about the provisions under the 2004 Act?
Well, the 2004 Housing Act gave local authorities the power to take action if they inspected residential premises and found what are called Category 1 or Category 2 hazards. If they found those hazards, then they could take enforcement action by way of service of one of, I think, offhand 3 types of notice and force the landlord to put them right. But that procedure is frankly lengthy because it has to take into account the possibility of landlords appealing the statutory notices and the delay that caused. And it also provides the tenant with no compensatory redress. They can't get damages for that. And added to that, since those powers came in, many local authorities have actually struggled within budgetary constraints to react to the volume of complaints that they may be getting if it were publicised more widely. So in short, a direct covenant between the landlord and tenant in every short letting of a residential dwelling provides a remedy for unfit housing that has been lacking before and has been lacking in any meaningful sense since at least 1985.
Yeah. So what does the new Act do then?
Well, as we've discussed, rather like Section 11 implies an obligation into every lease to repair the structure and exterior and so forth. The Act now creates a further implied covenant, so a further obligation in every short lease of a dwelling house. It's contained now in Section 9 capital A of the Landlord and Tenant Act of 1985, and it's a covenant that the premises must be firstly fit for human habitation at the time of the grant of the tenancy, and that they remain fit for habitation during the term of the tenancy.
And what does fitness for human habitation actually mean?
When considering fitness, you have to look at Section 10 of the Landlord and Tenant Act, which has been amended. But regard has to be had to the condition of the dwelling house in respect of a list of matters, the principal among those being repair, stability, freedom from damp, but also, and this is the novelty from the Fitness for Habitation Act, any prescribed hazard. And those are the hazards that are contained in the Housing Health and Safety Rating System, which was brought in by the 2004 Housing Act that we've already alluded to.
So what kind of things are we talking about? What kind of hazards are Category 1 and Category 2 hazards?
Well, the category of the hazard depends on the nature and extent of it and the likelihood of risk of harm. But the hazards themselves are many and various, and under the HHSRS, I think there are about 29 in all. Some of those hazards are obvious and some are not. But again, the most important ones are likely to be things like damp, however caused, excess cold, excess heat, carbon monoxide. Interestingly, noise is included, falls between levels, downstairs, falls on level surfaces and out of baths and the like, electrical hazards, and also fire.
And one thing that I'm sure landlords will want to know is, does this include damage that's caused by the tenant?
No, it doesn't. It is expressly excluded in the amendments to the Landlord and Tenant Act of 1985 by Section 9A, subsection 3. So assuming that this damage is in breach of a tenant's covenant, which it is likely to be, because even if there isn't something in the tenancy agreement, there's an implied covenant to use the premises in a tenant-like manner. Damage caused by a tenant in breach of that covenant or an express covenant is excluded. You don't have to repair it as a landlord.
And what about if the tenant hasn't given the landlord any notice of the defect?
The Act itself is silent on that, but it has been for a long time, the position under Section 11, that there's an implied precondition of any liability, that the tenant notifies the landlord of any defect of the premises. That is perhaps for obvious reasons, because the tenant is living there, they experience the condition of the premises day to day, and the landlord isn't living there and does not. So the tenant needs to inform the landlord of the defect or what is wrong with the property. The exception to that is where the premises were unfit for habitation when they were originally let, because it is presumed the landlord will have done an inspection of the premises for the purposes of, say, an inventory, or simply because they need to be checked and cleaned and ready for letting. So if they were unfit at the time of the letting, the landlord will be fixed with that notice in any event.
And what does the Act say about access?
Well, access to inspect and repair the premises is in almost all residential tenancies reserved as a right of the landlord in any event. But the Act does make express provision for this. And so whilst there is an implied covenant to keep the premises fit for habitation, there is also an implied covenant for the landlord's benefit that the tenant will give the landlord access to inspect and repair at reasonable times of the day and on 24 hours written notice. And
just for clarity, this says it applies to tenancies. What about license agreements?
There is nothing in the amendments to the Landlord and Tenant Act of 1985 which makes this apply to what are bare licenses of residential accommodation. There is constant reference to the lease and the tenant and the landlord. It applies to tenancies, all tenancies that are for a term of less than 7 years. So the vast majority of the short-hold tenancies, assured tenancies and secure tenancies. It also, though, applies to secure tenancies and assured tenancies granted by registered providers for a term of 7 years or more. Yeah. You don't come across those very often, but in practical terms, it's going to cover all sorts of residential lettings. But what it doesn't cover is premises that are held pursuant to a license. So if you have, for example, temporary accommodation or homeless persons granted by a local authority, they're excluded from security by paragraph 4 of Schedule 1 of the Housing Act of 1985. They are licenses or non-secure tenancies. If they're simply a license, then they won't be included. If they are a tenancy, then they will be included. But for temporary accommodation for local authority, homelessness accommodation, that still has to be suitable, which may provide some reassurance to the tenant. And from my reading of the Act as well, shared ownership leases are also excluded from these provisions.
If there has been a breach, what are the remedies that a tenant can seek? Just
like with Section 11, there are essentially two principal remedies. There is a remedy in damages. Breach of covenant attracts contractual damages. But the Act also makes explicit that the tenant can seek an order for specific performance of the covenant. So the court can make an order if works to remedy the condition of the premises haven't been carried out. The court can make an order within a specified time that the landlord enter and rectify the defects to the premises to render them fit for habitation. And now that's explicit in Section 9A, subsection 5 of the Landlord and Tenant Act. Interestingly, though, the Landlord and Tenant Act also provides that the court may grant a specific performance order, regardless of any equitable rule restricting the scope of that remedy. So the Act itself actually ousts some form of equitable jurisdiction, which would come as something of a surprise to John Scott, the first Earl of Eldon. So, for example, things that would ordinarily bar an equitable remedy would be coming to the court with clean hands. So the tenant could be a crook, but they are still required to have premises fit for human habitation. And leachees, which are not a dessert in a Chinese restaurant, but equitable delay. So the tenant could delay for as long as possible, or for as long as they wanted to, and still not be barred by any form of limitation under those equitable rules, because of the way Section 9, subsection A5 is drafted. So where a tenant is seeking damages, do we know how those are likely to be determined? Well, currently damages for disrepair, breach of covenant implied under Section 11. There are obviously two different types of damages. There are special quantifiable losses. They will continue, subject to the tenant being able to prove that those items have been damaged beyond cleaning or repair and damaged by the condition of the premises. But also general damages for the loss of comfort and convenience incurred by occupying premises that are unfit. The general damages are assessed effectively as an annual figure, and that is more art than science, but it's then cross-checked against a notional discount from the annual rental figure, depending on the severity, the nature and extent of the disrepair. So my in particular view is that damages for breach of the fitness covenant are likely to be higher than those for structural disrepair. Because given to establish liability, the tenant has to prove the premises were not reasonably suitable for occupation. Yeah. Now that's actually quite, it's quite a high hurdle for the tenant to overcome, but once they have overcome that hurdle and proved that to the satisfaction of the court, it seems to me that the damages, the general damages that will follow, will be commensurately higher. I mean, there have been dicta in previous cases that have awarded up to and close to 100% of the annual rent as damages where the premises have been virtually uninhabitable. And if you take virtually uninhabitable to be on a par with not reasonably suitable for occupation, then landlords could be in for a shock if they're actually in breach of this new implied covenant. What can landlord do then to ensure compliance, that they don't fall foul of these new rules? A lot of it is going to depend on common sense, but it's also going to involve a significant degree of proactivity. For private landlords, the assistance of an experienced and reputable letting agent can be invaluable because practical steps can be taken on their behalf, but also things like taking inventories at the commencement of the tenancy, photographs of the premises at the time of letting, to avoid any suggestion that they were unfit at the very commencement of the tenancy, will be, I think, almost standard procedure. For larger scale landlords, again, proactivity, a significant and robust void inspection system prior to letting. That's got to ensure that, unlike currently, the premises are inspected not just for disrepair, but also for sufficiency of heating, ventilation, protection from falls, and all of those hazards that are specified. Many landlords, large-scale landlords, also carry out annual tenancy inspections to ensure no repairs are outstanding, to ensure the tenants' needs are being met and their vulnerabilities are addressed. But this is also a golden opportunity to check the premises for obvious hazards. And those that are carrying out those inspections need to have sufficient training to ensure that this is, if not at the forefront of their mind, then certainly one of the things they should be checking on any such visit. It seems expensive, I know, but it will pale into insignificance compared to the legal and expert costs of defending county court claims that are brought under the Act.
And when cases are brought, how do you think it's likely they'll be funded?
As we all know, the scope of legal aid has been restricted in such a way as to take away from it the overwhelming majority of claims for disrepair. And so one is left with disrepair claims being brought as a counterclaim if legal aid funding is going to exist. They are predominantly now brought under a conditional fee agreement, and that is likely to continue. But one interesting feature of the drafting of the new Act is that it is all done by reference to the HHSRS standards. So they are part of the standard of fitness for habitation. If the hazard falls into category 1 or 2, but most likely 1, being a significant risk to the health and safety of the tenant, then legal aid could still be available. Because if one looks back to Section 2 of the Housing Act of 2004, a hazard is described as a risk of harm to the health and safety of the occupier. Mm-hmm. And harm is defined as including temporary harm, and health includes mental health. So the Legal Aid Funding Code, which ordinarily excludes claims for disrepair, does provide that legal aid is available if there is a risk to the tenant's health and safety. So if there's a category 1 hazard, which feeds into whether or not the premises are fit for habitation, then it seems to me likely that a disrepair claim could be funded by the legal aid agency, at least until that category 1 hazard is rectified.
And do you think that there might be a decrease in EPA prosecutions?
I think that is almost certain. I think, given what we discussed earlier about how cumbersome and how potentially time-consuming and unfamiliar the magistrates' court process is, the ready availability of a claim for damages and specific performance in appropriate cases in the county court is going to mean that EPA prosecutions are much less likely than they were. And there is also, of course, the pre-action protocol, which is tailored to this type of claim. So I can see magistrates' court prosecutions tailing off quite substantially as a result.
If a landlord now receives a complaint regarding housing conditions or even a pre-action letter, what's your advice to them in how to deal with that?
Well, the first thing is if they receive a complaint, they go through essentially the repairs procedure, but they need to be looking for things that go above and beyond repair. So they need to have in mind the list of HHSRS hazards, potentially speaking. So get in, inspect, draw a list of any necessary works, those works may not simply just be repair. They may have to contain improvements to improve the ventilation or the heat retention of the premises, and get them complete within a reasonable time, which in common parlance is as soon as you possibly can. If you receive a letter of claim, then follow the protocol. There's no particular magic in advising anybody to do that, but that is what is expected of you when the matter actually, if the matter gets to the county court.
Considering the circumstances that we now find ourselves in, does the Act still apply to conditions of properties during the COVID-19 pandemic and the lockdown that we're under?
Yes, it does. Just as the current government guidance makes clear, the pandemic is not a reason for or a moratorium on the tenant's obligation to pay rent. So the flip side of that is the landlord's obligation to repair and maintain and keep premises in a state that is fit for human habitation still remains. The guidance does emphasise that this has to be done in a collaborative way and constructively within the guidance and guidelines of Public Health England for distancing and trips to work only when necessary. I mean, essentially, if the defect or hazard is serious and urgent, such as a hole in the roof or a wall in imminent danger of collapse, the landlord should take steps to carry out at least an interim repair. Well, likewise, if the defect is less serious, the landlord should consider asking the tenant if, in these exceptional circumstances, that repair can wait. And at all times, both parties, both landlord and tenant, to protect themselves, apart from anything else, keep a record of the steps that have been taken to agree a delay to or rectify any urgent problems.
And what's the landlord to do if, for example, a tenant is self-isolating and is refusing or reluctant to give access for repairs?
Then I think, as above, both parties need to bear in mind the current guidance. Urgent matters will require urgent attention, but the landlord and tenant should think creatively. If you're in a situation where the tenant has a smartphone and the landlord's repair officer has a smartphone, then think about doing a video call, whether it be WhatsApp or FaceTime or anything of that nature, and get the tenant to walk around the property, pointing the video camera at the things that they say are in disrepair. Then the officer can virtually inspect, if you like, while keeping the requisite distance, but also identify as best he or she can what needs doing as a matter of urgency.
Thank you. I think that concludes the webinar. If anyone watching would like to get in touch with either of us, our details will have been sent out to you in the email that you've received. We also, I think, will be sending out a feedback form. So this is the first of these that we've done, and obviously we'd appreciate any feedback or suggestions that you have, topics you'd be interested in hearing about, and so on. So all that's left to be said is thank you, Tom, and maybe stay tuned for any bloopers. Right, okay, let's start.
Well, perhaps before going on to that. Right, cut.
Oh yeah.
So we start again from there.
And my dog is now chosen now to just barge into the room. Interesting. With damages, do we know how they'll be determined? Stop laughing, I thought it was interesting.
If you think it's interesting, you've got to try and sound sincere, Alice. Okay.
Moving
Can we
on.
go from interesting again? Yes, it does. In most conditions of tenancy,
Stop it.
you started that.
So it's because you went, yes, it does.
All right. Okay. Right. Can we? I'm just going to put my serious face on.
Okay.
Yes. Do you want to give me the question about access again? Please do fill in your feedback forms, because that helps us to help you If you have any suggestions as to the format, the content, or how we could make it more user-friendly for you, then please don't hesitate to let us know. And thank you, Alice, for asking the questions. And I'm off to milk the pig.
Oh my God.